One of the good things about being an old-timer in the community association industry is that I've worked alongside other industry veterans for many years who have decades of experience serving associations in their particular area of expertise. One of those treasured individuals is Adrian Adams, an influential community association attorney who leads a prominent California law firm. Adrian and I have observed for years how boards regularly fail to understand the battle they are in for the future well-being of their association. Because Mother Nature and Father Time dictate the cost of this battle, it's up to the board to understand the seriousness of their situation and how their decisions are guided by things like fiduciary principles, the business judgment rule, and governing documents. So, settle in for this portion of our webinar on the legal responsibilities of the board regarding reserves, as Adrian so clearly walks us through the rules of engagement for this battle for the future of the association. So now I'm going to turn the pages to a new chapter here in our presentation. We're going to talk about the rules of engagement. And these are basically how we're going to address this challenge. What tools do we have? What are the rules that we need to follow? And for this portion of the program, I'm very pleased to have my friend and long-term colleague in the community association industry and a experienced expert in the legal profession, Adrian Adams. So Adrian, let me hand it over to you at this time.
Okay, thank you, Robert. Let's go. There you go. Rules of engagement. The factors, fiduciaries. And I saw that you have a lot of board members attending this, which is good, and managers as well. For boards, directors, once they're on the board, as soon as they're elected, they become a fiduciary, which means they're held to a higher standard. And one of the things that homeowner associations are created to do is to manage common area. I mean, that's exactly why they're created. And then you have an elected board of directors that oversees those common areas, which means that they have to make sure that they're safe and that they're well maintained. And that's where reserve studies come into play, because you've got components that have a longer life and at some point will need to be replaced. And boards of directors have to anticipate that and prepare for it. And that's where reserve studies come in, setting up a separate reserve account and putting away monies on a regular basis so that the money is there when you need it. Earlier, you had a slide about directors aiming at the wrong target or missing the target entirely. There was an association, I was called in as an expert after they got sued. And what the board had been doing was that they had a number of people living in their condo association that were on fixed incomes. And so what they did was they decided we're not going to raise assessments so that we don't drive them out. And they went, trying to think, 15 years, no assessment increases.
Ouch.
And they stopped contributing to reserves and deferred maintenance built up. And what happened was that then the roofs got to a point that one winter when there were heavy rains, water just poured into units all over the complex. That resulted in lawsuits being filed, insurance taking it under reservation of rights, damage due to the failure to properly maintain the roofs. And at the end of the day, the association had to impose large special assessments to pay for all the damage, and then also to pay for new roofs. And what happened was that all of those people that they were protecting on fixed income, they were defaulting on their mortgages, or they're being forced to move out because they couldn't pay the special assessments, and they're selling their units at now below market because of all the special assessments and deferred maintenance. So, it's important that boards know what their responsibilities are and meet them. And if you'll go to the next slide, and if they do that, they're going to be protected by the business judgment rule. And the business judgment rule says that a director can make a mistake in judgment and end up in a lawsuit, but not be personally liable if they follow these three steps, these three legs of that stool. The decisions they make must be in good faith, in the best interest of the association, and after reasonable inquiry. Okay, so what this board in this particular association were doing is that their hearts were in the right place, that they wanted to protect the older individuals of fixed income, but they certainly were acting in the best interest of the association. And at the end of the day, they were not acting in the best interest of those individuals, those older fixed income people, because they were forced out of their units. So if boards follow these steps, making decisions, good faith, best interest, reasonable inquiry, they're not going to be personally liable, even though they make a mistake and end up in a lawsuit. So if you'll go to the next one, going back to Champlain Towers, which you mentioned, everybody got sued in that, board members, everyone, and ended up the settlement was up over $1 billion.
Yeah, I think it was just about that.
And thank goodness it was settled rather than go to trial.
Yep.
Because, there could have been what deemed criminal negligence involved, and directors would have been seriously at risk. So this is why it's important that board members take care of the financial aspects of the association, because those finances are what they need in order to take care of the common areas, which is the whole point of an association being set up. So as long as they do that, then first of all, they're not going to end up in lawsuits, because they're going to be funded enough that they can take care of what they're supposed to be taking care of. Okay, let's go to, let's go back up for just a second. On the governing documents, one of the things that boards should do is to take a look at their governing documents. One of the elements that came up in that first lawsuit was the issue in their CC&Rs that said the association must maintain their common areas in a first-class condition. That became a real problematic issue for the association in that lawsuit. And the court specifically questioned me when I was on the stand as an expert, what does that mean? Because it puts it at variance with the whole concept of what a reserve study is supposed to do. With reserve studies, you're allowing a component to go towards the end of its life, and then you have the money to replace it. Well, if you're supposed to maintain it in a first-class condition, what does that mean? Does that mean it's never going to reach the end of its life? And so we amend documents whenever we see that in a set of CC&Rs. We amend them and take that out and put in different language. Okay, let's go to the next slide. Okay, so in addition to governing documents, you have state laws, and then you also have a federal agency involved, and that's Fannie Mae. So different state laws may have different requirements as to what boards must do when it comes to, first of all, just a reserve study. And Robert, you know how many, because you're nationwide with your company, how many states have requirements that there be reserve studies?
Well, it's about 25 states that have some requirements with respect to reserves. It may be a reserve disclosure. It may be a reserve study every X number of years. It may be a reserve funding requirement. So it's different in different states, but roughly about 25 states.
Yeah, and in California, there's a requirement that a reserve study be done, be updated annually, and then an on-site every 3 years. But there is no specific requirement that it be funded. But there are indirect requirements. As part of their fiduciary duties or responsibilities to take care of the common areas, they need to have funded reserves, because without it, they can't take care of the common areas. So it's important, to be looking at first of all, what your state requires, secondly, what your governing documents require. And then you've got other factors such as Fannie Mae stepping in because the Champlain Towers collapse, and they changed their lending requirements, questionnaires, so that they want to know, as an association, are you taking care of the common areas? Do you have anything that you've neglected? Because if you have, we're not going to loan in there. So they'll blacklist the association. So it's really important that boards set up reserve funds, properly fund those, and then take care of the common areas, those components, with those reserve funds. Okay, let's go to the next one. Okay, reserve costs outside your control. So as this slide points out, budget assessments or special assessments. If you've got underfunded reserves, you're looking at special assessments. They're inevitable. And special assessments can be very costly. And as this next slide shows, the owners pay either way. They're either going to pay incrementally going into reserves that will then earn interest, or they're going to be facing special assessments and bank loans where they're going to be paying interest. And it's much more expensive to go that route than to simply set aside reserves and fund it properly.
At Association Reserves, we make the present less stressful and the future more secure. If you want to join us in this mission, please like this video and subscribe to our channel. Leave a comment down below on what you'd like to see us address in a future video. Let's plan for your best future.